All right, sir, is your name Jason Brown?
Yes, sir.
So on the record is People versus Jason Brown, file number 256851. The record should reflect Mr. Brown is appearing today by video from Otsego County Jail. If I could have counsel put your appearances
For
in.
the record, Your Honor, Michael on behalf of people, Larry Brown on behalf of Jason Brown.
Attorney Brown, can you tell me what the status of this file is today?
Your Honor, this is a relatively new case. It was just found over first appearance in the circuit court. I am going to request a 30-day adjournment. I did send a copy of the discovery to him while he was in prison. However, he does not have it anymore. I need to get him another copy, which will drop off today. There's also been a plea offer in the matter, which I need to discuss with him thoroughly, especially given the nature of all of these charges.
Mr. Rolla, do people take any position on that request?
I don't have any objection, Judge. In fact, I would confirm for the record that an amended plea offer was provided on May 14, 2025. And then if the court will recall, we had issues where the defendant was admitted into apparently Ford Hospital in Jackson for some issues. And I believe because of that, counsel was unable to have communication with this client.
Okay, Mr. Brown, were you able to hear all of that?
Yes, sir.
Okay, do you have any questions about how we're going to proceed with your case?
No, Your Honor.
Okay, so the court will set this for hearing in about 30 days. If we have a plea agreement, then Mr. Brown, I'll need you to communicate with your attorney between now and then about that plea agreement and be ready to with a decision as to whether or not you want to enter into that plea agreement at that time. Okay.
Yes, Your Honor.
All right, Mr. Rolla, anything else we need to address in this file?
Not to the people. Thank you.
Mr. Brown.
No, Your Honor, thank you.
Okay, thank you, Mr. Brown. That's all for today. The court is going to disconnect at this time.
You're welcome. Thank you. Have a good day.
Thank you. And People versus Marcus Clark, file number 20002, that was set for hearing at 1:30.
Yeah, for the record, Your Honor, Michael on behalf of people.
Larry Brown on behalf of Mr. Clark.
Mr. Brown, have you had any contact with
Not. The last phone number I had on file, somebody else answered the phone, apparently didn't know what I was talking about. With voice message, never got a call back. It wasn't Mr. Clark. And I did have, excuse me, an email address on file. I did send him an email and have not heard a response from that.
Ms. Davis, do you have any updates?
I do. He is reporting every month. However, when we were here back in March, we adjourned at 90 days for him to make $400 payments for April, May, June. He's made no payments. He has changed his address probably since the court hearing in March as well, which I told Mr. Brown that I can give him all that information. So I don't know if you want to adjourn this to your mid-motion. He is supposed to report tomorrow for report day, where I can verbally tell him as well. And then I could send Leanne as well his new address, so he can get that mail.
Okay.
Whoever needs that sends out the notices.
Okay, I will ask that you provide that address to and Mr. Brown. We'll adjourn the hearing for today and set it for court's June motion day, and then we'll see if Mr. Pierce.
Okay.
All right. And we have that's it for your cases, right?
I believe it is, Your Honor.
Mr. Baber, are you able to hear me okay?
I am, Judge. Can you hear me okay?
Yes, thank you. We'll go on the record in People versus Jeremy Brokaw. This is file number 2526796. The record should reflect Mr. Baber, who's currently counsel of record, is present by video. We have Mr. Rolla on behalf of the people present here in the courtroom. Mr. Baber, this is your motion to withdraw as counsel. I did receive your motion. I had a chance to review that. Was there anything that you wanted to state for the record?
Just that I have not had any communication with my client since the day he missed for his sentencing. I do not believe that this would be an inconvenience for the court, nor do I believe it would impact my client's rights to substitute an attorney out this late in the game, considering we've already gone through the plea phase, we've already gone through the PSI phase. Very limited situations could my client actually withdraw his plea, so I don't believe that there's going to be any harm or prejudice on either party with my withdrawal.
Thank you. Mr. Rolla, do the people take any position?
No, you're okay.
All right, having reviewed the motion, the court finds that there is adequate grounds to grant the motion to withdraw. The court also would note that the proposed order submitted by Mr. Baber includes a provision for the appointment of new counsel for Mr. Brokaw. And I agree, given the status, procedural posture of the case at this time, that a substitution of counsel would not impact his substantial rights. So the court will grant the motion, and I've signed that order, Mr. Baber. Is there anything else I can address for your side today?
No, that's it, Judge. Thank you for your time.
Mr. Rowland?
Nothing further, thank you.
Okay. The only other thing I would note was this hearing was set for 1:38 today. I'm sorry, 1:30. It is now 1:38. Mr. Brokaw did not appear to contest the motion. So that is all for the record. Mr. Baber, you're free to disconnect at this time.
Thank you, Judge. You have a good rest of the day.
Thank you. Our next hearing is at 2:15. That's by Zoom. Mr. Rowland, did you want to stay here to?
Judge, I might just go into the crime victims' rights room for a bit, do some work, and then be back with the court permission.
Okay.
If you want to do it by Zoom, I can appear by Zoom via the crime victim rights room as well. So.
Why don't you can appear by Zoom, and then let's do that. That way we can.
That's probably
release the
the
court
thing.
officer. He can go.
Exactly, I didn't want to
Do
inconvenience
I need
people.
to be
Have to.
here for this
Um,
on
I
Zoom?
mean, there's a question of jail credit that they raised. And a question of restitution. So the jail credit maybe. Can you get on Zoom?
Yeah, I can do that, and then it'll give me a chance to go look it up in calculator too, because I think. I don't know, I didn't do this before, so. Thanks for that.
Yep.
I don't know if Maya got it or not.
Okay, thank you. We'll go off the record until 2:15. Okay, Mr. Egger, if you could unmute, please. Thank you.
Yes, Your Honor.
All right.
Sorry about that.
That's okay. We'll go on the record in People versus Jason Allen Evans, file number 236554. If I could have both counsel put your appearances on, please.
Good. Your Honor, for the record, Mike Roll on behalf of the people.
And good afternoon, Your Honor. Jason Eggert from the State Appellate Defender Office on behalf of Mr. Evans.
Thank you. We're on the record today for defendant's motion to correct an invalid sentence. I do not see Mr. Evans connected at the Department of Corrections. Mr. Eggert, were you anticipating his virtual presence today?
I did see a writ was entered. I mean, if there's a problem with the writ, I can always schedule a visit with him and give him a recap of today's hearing and would waive his presence. But I thought the court issued a writ, but I may be mistaken.
Okay. Let's see. Did you, oh yeah, I signed that on May 19th.
Yes, I just found the same document.
Yeah.
Judge,
So
Parnell confirmed the writ back on June 4th, for today at 2:15. That's what we got, the contact and fax number for that from Ms. Chesley Kelly from the Department of Corrections. So the writ was prepared, the writ was signed, the writ was served, and it was received by Parnell, and they confirmed they would honor the writ.
okay, so Mr. Eggert, did you want to proceed? If Mr. Evans does sign in, of course, I'll bring him into the meeting, but
Yes, Your Honor. I think it makes sense to proceed. This isn't a hearing. I'll just add for the record, this isn't a hearing that's evidentiary in nature that would require Mr. Evans' presence, as it's just an argument on the motion. But yes, I would waive his presence for the purposes of this hearing.
okay, thank you. So again, the motion is to correct an invalid sentence. I reviewed the motion and supporting brief. Appears to me there's two bases for the motion. Number one, an incorrect calculation of jail credit, asserting that Mr. Evans is entitled to an additional 120 days of jail credit. And then number two, that the court improperly imposed restitution in the amount of $275. Mr. Eggert, was there any oral argument that you wanted to make today in support of your argument?
Your Honor, I think the motion essentially speaks for itself. You know, with respect to restitution, I think it's even clearer with the McKinley case and in the Foster case from the Court of Appeals and the holdings in those cases. So I'll just rely on the motion unless the court has questions.
I don't. Mr. Rolla, anything in response?
So just the latter matter, the cases cited by appellate counsel, quite frankly, do not apply. Because in this case, as evidenced by, first off, Exhibit C attached to our brief, that's the register of action. I'm sorry, the judgment of sentence, and then Exhibit E at lines 79 through 81 in the register of action. Restitution was made part and parcel to Sane as part of the party's plea agreement, the amount of $270. Also, as attached, the exhibit of the email that was sent corroborating that particular information. And perhaps if that weren't enough evidence for the court to confirm that restitution was part and parcel of the plea agreement, as indicated in the register of action, the basis for the court accepting the defendant's plea of no contest to counts 2, 3, and 7 as evidenced in Exhibit A was the fact that there was restitution that was due and owing. So for all of those reasons, Your Honor, the reliance on the cases where there is actually no definitive part and parcel of the plea agreement do not apply. As to the jail time credit, as also indicated in our brief, the situation was that the time that the defendant is claiming he has credit for, the court is well aware that you can't give credit for time serving on other matters. That was the case here. One other Otsego County case, one other out of county case, as evidenced in the documents in support as attached to our brief. For all of those reasons, Your Honor, we think that the motion should be denied.
Thank you. Mr. Eggert, it's your motion. Anything you wanted to say in response?
No, Your Honor. I think that the record states what it says. I do think that this is distinguishable, I just will say, from cases like the Idziak case from the Michigan Supreme Court where individuals are on parole. To the extent that this is, could be viewed as a law reform issue with respect to jail credit, I think the statutory language does not stutter. The plain language would require jail credit to be given to Mr. Evans, but I just would rely on the motion.
Okay, thank you. Addressing first the issue of restitution, since we kind of talked about that first. I did review the file. I reviewed the transcript in particular of plea hearing. And I think Mr. Egger properly cites case law regarding restitution and that it does have to relate to a conviction and it cannot be based on a course of conduct that does not result in a conviction or uncharged conduct. So I think the statement of the law is correct. And Mr. Eggert also points out there is an exception where restitution is made part of a plea agreement. And in this case, I find that that's what occurred based on the plea transcript of August 7th of 2024. On page 4 and lines 9 through 14 of that hearing, when the court asked the parties to recite the terms of the plea agreement, the prosecutor indicates that the restitution is part and parcel of the plea agreement. I then inquired of Mr. Evans' counsel whether that was part of the plea agreement. Mr. Trush, was Mr. Evans' trial attorney, indicated that they were not contesting that amount of restitution as part of the plea agreement. So I find that that is an exception that would allow the court to impose restitution and that it was part of the agreement between parties. So for those reasons, the court finds that restitution was properly ordered and would not be a basis to correct the sentence. In terms of jail credit, I did review the files. I reviewed Mr. Evans' status at various points throughout this case because he was being held in other jurisdictions, I believe Alpena County, during most of the pendency of this case, and was otherwise under different jurisdictions. In my review of his status throughout the case is that jail credit was properly calculated and that he was not entitled to earn jail credit on this particular case until the time as indicated by the people in their response brief. So the court adopts the people's argument. The court finds that it is supported by the record evidence in this case. Again, I think Mr. Eggert accurately cited the law that applies. I agree with the people's interpretation of Mr. Evans' status throughout the pendency of this case in terms of how much jail credit he's entitled to. So for those reasons, the court finds that that also does not need to be corrected. And so the court will deny the motion. And Mr. Eggert, I would just request that you submit an order either under the 7-day rule or with a stipulation as to form regarding the court's ruling for the file.
Okay. I can prepare one of those and I'll email it to the prosecutor so he can look at it for his approval.
I'm going to suggest that it save some time. We can just email it to my office with a approval, and then I can have you sign it with permission.
Okay. All right. Well,
Makes
thank you
sense.
very much.
Okay, very good. Thank you. That concludes this hearing and all parties are free to disconnect.
Thank you.
Thank you, Your Honor.
That also concludes the court's docket for the day. The court will be in recess.